First of all, I would like to continue on expressing gratitude for this honor and very successful research to be part of this group. Special gratitude to Professor Silegy because of his coordination during this past year. And this time, special thanks to students because of their passion and concentrated to be with us up to the end of this conference. My topic of my research for this presentation is private law aspects of environmental protection and sustainable development. Where is the line between public and private interest? Protection of the environment, I will try to be short as much as it possible. For the beginning, I would like to make some comparison between environmental law and civil law. Characteristics of the environmental law is, first of all, its complexity, multidisciplinary, and majority of imperative norms. That means that protection of the environment is regulated by numerous laws and bylaws within all legal areas. As regards regulation of imperative nature, there is no doubt that these provisions actually represent public interest and the responsibility of the state to preserve and improve of the environment. A huge number of regulation per se illustrates the need for the legal intervention in order to guard the environment for future generations. And major provisions with environmental matters is directed to set standards in the environmental protection, to prohibit some danger actions. And for that purpose, provisions which subject of environmental law are equipped with different kinds of measures in order to achieve and maintain the desired standards of the healthy environment. Basically, characteristics of civil law are quite opposite because it's the area of law which has private interests in the central part, and right holder has freedom to decide whether or not to exercise his or her rights, when and how to exercise it, etc. The freedom of the will in civil law is limited by imperative norms, public order, and good business practices. And having in mind that the healthy environment is of the constitutional relevance, the civil law rights indisputably could be restricted due to care of environment. The Constitution of Serbia contains explicit provisions in this regard. The legal system of environmental protection in the field of civil, or rather in private law, lays in restrictions because there are a lot of provisions that restrict some rights which are civil in their nature, and of course a lot of provisions in legal system is related to post factum measures like damage compensation or actio negatoria, actio popularis, and my today presentation will not touch this question because the question is actually devoted to some indirect link to the environmental protection. Indirect link to the environmental protection is about supportive measures with the aim to develop society and at the same time to preserve environment. Of course, when we talk about supportive measures and improvement, it is necessary to mention intellectual property law, and from this point of view there are several frameworks, to say it in that way, for the supporting creative actually inventives. In European Union there are climate neutral goal by 2050, which is in the core of the European Green Deal, and the new strategic investment facilities are well equipped for that aim. But as regards inventions, invention is not goal for itself. Namely, with the recognition of a patent for technical invention that is new, has an inventive level, and is industrial applicable, the holder exclusively acquires the right to exploit the subject of protection for a limited period of time. In other words, holder is authorized to exploit the patented invention, but also to prohibit all third parties who do so without his consent. By doing so, he gains a market advantage over his competitors and consequently financial gain. It is precisely in the privilege of exclusivity, which is which a patent provides, that there is an incentive for further technical and technological improvements. Economic implications of patent protection go beyond the interests of the individuals. What is very important is that it is clear that normative regulation could significantly influence the development of the internal market as well as attraction of foreign investments. In developed countries, investing in inventiveness is unquestionable way of the technical and technological development, because they are not from the other side, undeveloped and developing countries do not have the condition for the development of their own technologies. Therefore, their further development depends on the import or transfer of technology from developed countries. For the above reason, this transfer requires at least the minimum of the patent standards, actually patent protection. The global character of sustainable development imposes an even greater obligation to relevant entities to find solutions that would satisfy both conflicted interests to the greatest extent. The starting point in determination of the patent framework of sustainable development is in the question whether technology based on saving of natural environment should be excluded from patentability, or if there is some other measure to make that technology available to state, actually to citizens. There are some scholars that have opinion that that kind of technology should be excluded, but I explain what is the reason why patents are so sensitive issue regarding the market competition. Certain international acts among TRIPS is certainly the most important. Leave some space for sustainable technology to be separated for the general regime of the patent protection. As regards Serbia, I would like to point out these three aspects in our national system, national law. Serbian legislator takes a neutral position in this matter. That means that the provision on exceptions covers just inventions that are against the public order and morals of society, and inventions that harm the life and health of people and animals, but not inventions that could seriously damage the environment. That means that patentability is accessible, patents are accessible even for those inventions that are danger for environment. But law on patents of Serbia provides several situations in which a compulsory license may be granted, even though all of the provided cases under certain circumstances could be applied. For this research is the most relevant compulsory license in the case that exploitation of the patent is in the public interest for the purpose of protecting health, nutrition of the population, public interest in areas of vital importance for socio-economic and technological development, or for the purpose of protecting competition in the market. Although not explicitly stated, the need to preserve the environment is a legitimate reason for issuing a compulsory license, even more because the preservation of the healthy environment is the reason for restriction of some other constitutional rights. These inventions are patentable, and consequently it is possible to register a patent for sustainable technology of foreign origin. This creates favorable conditions for the foreign investments And in this sense, issuing a compulsory license can represent a way to exploit advanced sustainable technology on the domestic market or to develop domestic invention. However, the widespread practice of approving compulsory licenses could have the opposite effect. Discourage investments by foreign business entities. Thus, in order to avoid compulsory obligation, a foreign company can decide not to register patent in Serbia, and in that case, protected inventor products, which could be of the importance for green technology, wouldn't be able to access on domestic market. So future development should be based on two simultaneously processes, the stimulation of invention in the field of sustainable technology and the creation of conditions for their full-scale economic exploitation. This proclaimed goal is in accordance to Serbian United Nations Agenda 2030, and to achieve the sustainable industry that supports clean technology, and of the great importance is to reduce the emission of the CO2. Moreover, there is an unfavorable ground for the enhancement scientific research, improvement of technological capacities, and incentives the innovation. When it comes to stimulating innovation in the sphere of the green technology, there are encouraging circumstances according to the strategy for scientific and technological development of the Republic of Serbia for the period 2021-2025. Environmental protection and climate changes are of the highest priority for the researchers. The sustainability of the public finance demands balance between incomes and outcomes in environmental matters. So the Green Fund, which is established in 2016 in accordance to the law of the environmental protection, has the aim to make funds intended for financing the preparation, implementation, and development of programs, projects, and other activities in the field of conservation, sustainable use, protection, and improvement of the environmental. The question rises as to which entities are invited to respond to the expectation of the government and other authorities or organizations which invested in the research. The other question relating to intellectual property law, actually relating to stimulation, the improvement of environment, even more protecting environment, is indications of geographical origin. Indications of geographical origin shall be used to mark natural, agriculture, food and industrial products, traditional handcrafts products and services. It is common term for two types of indications of geographical origin: appellation of origin and geographical indication. Distinction between the appellation of origin and geographical indication is in the fact whether all phases of the production take place in a narrow locality or limited area, as it is the case with appellation, or just one of the phases in process of production or services, which is the case with the geographical origin. From the commercial point of view, indications of geographical origin enable certain advantage at the market. Namely, the products or services labeled with indication indicate that the distinctiveness of the goods, which is in the connection to the geographical locality. This fact usually impacts on consumers' choice which product would be bought or not. A higher value that consumers attach to the product originated from specific geographic location is expressed in a higher price for that product. Origin of goods gives them quality, reputation, or other valuable characteristics essentially attributable to its geographical origin. Undoubtedly, as regards national economy, indications should play an important role. It is the case with producers of goods who are authorized to use indications of origin as well. Moreover, this commercial advantage underlies the legal intervention into basically natural condition of the products or services success. Additional value of products created by indications contribute to the national economic development, the competitiveness of commercial entities, promotion of the tourist capacities, and all of these could enable higher employment, regional and particular rural development, and could protect traditional knowledge. But to understand completely the impact of indication of geographical origin on environmental matters, it is necessary to shortly explain differences between these two kinds of indications. While the geographical indication shall be registered when goods originating from the territory of the certain country, region or locality, where certain quality, reputation and other characteristics can essentially be attributed to its geographical origin, for the registration of the appellation of origin is required that the characteristics of certain products are exclusively or essentially conditioned by its geographical origin. The link between appellation of origin and locality is clear, and because all of phases of production takes place on the related geographical area. At the case of geographical indications, one of these phases must be taken on certain area, but not all. Mentioned distinction between two types of indication implicates procedural requirements as well as legal and commercial consequences. The indication of geographical origin is acquired by the entry into the register of indications, and its duration is unlimited. Status of the authorized user of indication is acquired by the entry in the register of the recognized users of the indication, and it lasts 3 years from the date of entry of granted status of recognized user, but it can be renewed unlimited number of times as long as the appropriate indication origin lasts. However, the status of the authorized user could cease, and that is very important regards the environmental protection, among other reasons, because of the fact that products have been changed, the quality of products and services for which authorized user got recognition, or the production has been extended out of the recognized geographical locality, or the technology of production has been changed. For this reason, authorized user would make extraordinary effort in order to preserve environmental conditions for his products. Drinking water could be considered the most illustrative product labeled by indication of origin, for which the user undertakes all necessary measures and improvements in order to guard its natural quality. As regards Serbia, even if there are a lot of water sources, just few of them are registered indications of geographical origin. Having this in mind, it is certain that the product for which indication is recognized has characteristics mainly attracted by natural conditions within the certain geographical area, and for that reason goods are often free from some danger or hazardous substances. There are few reasons for these consequences. First reason lays under the fact that product's quality and specific characteristics primarily depends on condition of geographical location. That usually means natural. Second reason, particularly when it comes to appellation of origin, has to be proven by experts entity, and from the very moment of application and further during the whole eternal period. As it is pointed out, the case of opposite situation could be the reason for seizing the status of authorized user of indication. And having previously in mind, an authorized user shall keep production which is in compliance with recognized quality labeled by indication of the geographical origin. That means that the user of indication should avoid technology or substances that could lead to the terminating of the recognized status. Even though there is no imperative regulation on environmental issues within the context of indications of geographical origin, it is obvious that producers of products labeled by indication are interested in preservation and protection of the environment for the reason of the safeguarding their own reputation and market success. And finally, regarding the environmental matters, the question is not where the link between public and private interest is, but rather is there line at all. More precisely, effective collaboration of private entities and state authorities depends on benefits for both sides. The task put in front of the authorities should be an identification of obstacles for cooperation of two mentioned sectors and efforts to eliminate them. As examination of patent demonstrated, cooperation between scientific research institutions and the industry is of the main concern in modern society, since fiscal obligations represent a burden on economic entities. A significant incentive in the intensification of technology transfer should come from the side of the state in the form of fiscal benefits. And similar approach should be suggested in relation to indication of geographical origin, since state and local governments should encourage entities to ask recognition or indication of geographical origin attracted to locality of high environmental quality. Therefore, environmental issue would be included in the determination of specific characteristics of product or service, and consequently in certain labeled goods. Thank you a lot for your attention.